We're making the management of our natural resources an issue for public debate.
I'm not a fisherman, but I'm a homeowner on the west side of Mille Lake, and I'm here to express my agreement with those who oppose what we understand the intent of the negotiations between the Mille Band of Ojibwe and the DNR under the direction of Governor Carlson. The issue of racism is being used to manipulate feelings with the purpose of distorting, clouding, and detracting from the issues at hand, which are, first, to ensure responsible government policy and management of our natural resources. Second, to ensure equal rights to all citizens regarding their use. Find the right place for this. The person who uses personal prejudice to discriminate against another in order to gain superior privilege or position for him or herself is in violation of the principle of equal rights. Likewise, so is the person who claims to be discriminated against in order to draw sympathy and attention from the facts as a ploy to cloud the issues so that he may gain superior privilege and position for himself. Some things are right and some things are wrong. The responsibility to protect, preserve, and restore the natural resources of our land, our waters, and our air belongs to all of us equally. And likewise, the privilege to enjoy them within the protective restrictions of law and sound government policy apply to all citizens.
Last year, $4.2 billion went through the budget of the Department of Interior's Bureau of Indian Affairs. Millions of these dollars are being used to file claims against the citizens of many states for money, land, and harvesting of very valuable natural resources. This is Ralph Dorsch with the Dorsch Report. This report centers around the court case in Minnesota filed by the Mille Band of Ojibwe. That is indicative of similar court cases which have been fought in northern Michigan, Wisconsin, state of Washington, Oregon, to commercialize very valuable fishing resources. In this case, the Bureau of Indian Affairs gave the Mille Band $500,000 to file this suit. In a similar case in New Mexico, the federal government has spent $300 million trying to determine whether billions of dollars worth of natural gas and land should go to the Hopi Indian tribe or to the Navajo. The Department of Interior's Park Service is now secretly acquiring state lands across northern Minnesota as well as land throughout the nation. Local tourist economies are collapsing and being replaced by bureaucratic budget deficits. A pattern of Indian court claims for harvesting natural resources seems to follow the federal land purchases. In Minnesota, for example, the Chippewas are using this money to sue Minnesotans in order to restore their game and fish harvesting privileges, the same privileges they had sold several times to the federal government and were paid for in the treaties of 1837, 1855, 1863, and 1864. These were temporary privileges granted to last during the pleasure of the President of the United States and ordered revoked by President Zachary Taylor on February 6, 1850. Well, sir, this didn't sit well with a number of folks, so our Congress set up an Indian Claims Commission to settle all old Indian claims forever. Over a period of many, many years, stretching throughout the 1950s and 60s, Congress told all bands which felt cheated to file a claim. Congress provided hearings in the Indian Claims Court and made final payments to such bands through the Indian Claims Commission. The bands which took the money from this commission agreed that they were forever barred from making future claims against the U.S. federal government. Congress closed its books on all Indian claims in roughly 1973. Well, that should have been that. But now Indian bands are seeking additional payments from various states. Currently, Minnesota's governor, the state's attorney general, and their political appointees in the Department of Natural Resources are all attempting to ramrod one such secretive, politically negotiated settlement through the Minnesota state legislature, rather than have the matter properly settled in court. Now, the Chippewa Band has been invited into and involved with these negotiations. In fact, band members have even been allowed to vote on this proposed settlement. Outside of the state government, however, Minnesota's other citizens, the business owners, the landowners, and so on, who are directly affected in this matter, were not asked or even allowed to participate. The Hunting and Angling Club feels this is grossly unjust, and it is supporting efforts of many private landowners to intervene in this case. Among other features, the agreement permits 3-inch gill nets to be used throughout the ceded territory on all of the lakes for rough fish. The agreement gives the band 50% of the harvest, and of course, just as with the porpoise, gill nets do not discriminate, and game fish will also be caught in these nets. The Hunting and Angling Club is the only organization supporting the efforts of the private landowners to intervene in this case. If the 8th Circuit Court of Appeals does not allow intervention, these private landowners are going to appeal to the U.S. Supreme Court. Now, what you're about to see depicts a group of concerned citizens attempting to make the proper management of our very valuable natural resources an issue for public debate.
Mr. Chairman, members of the committee, my name is Howard Hansen. I'm a businessman of 33 years in Minneapolis, own a fishing camp on an island in Rainy Lake at International Falls, and I'm also the president of the Hunting and Angling Club. History tells us Congress closed the books on all old Indian claims through the Indian Claims Commission, period. History now tells us that in the 1960s, presidents and Congress started politically changing federal Indian policy. During the next week, you will be asked to vote on an issue that will probably have the most far-reaching social and economic ramifications of any other vote you will ever make in your political lives. Having fought gill nets over here for the past 13 years, having spent thousands of dollars on expert Indian history anthropologists and Indian treaty expert lawyers, having read and studied how the Department of Interior and the Bureau of Indian Affairs in Washington politically uses and manipulates Native Americans, all for big business and all for big special interest greed. We are here today on behalf of the landowners in the ceded territory and other citizens of Minnesota whose interests have not been considered in this agreement. When the presidents and Congress politically changed federal Indian policy and put in place this new segregated doctrine of sovereign nation status to the Indian bands, we wonder if they knew what would be happening across our country 25 years hence. We wish they were here today. We wish all the big power brokers and greedy corporate contributors who helped them get elected were too, so they could see and witness firsthand the pain, the emotional strain, and the sadness caused by this divisive commercialization of our public waters and lands. This agreement before you today is phase one of a three-phase plan to pillage all of northern Minnesota's precious fisheries resources from the vast majority of the citizens to which they belong. During phase one, you will be told that the resource will be protected. You will be told that if you don't vote for this settlement, you will have racial chaos. And you will be told that if you go to court, you will lose. All these statements are false. During phase two, as the gill nets appear, as the fish start to disappear, as the economic decline begins, as discrimination is used to put gill nets in public waters, your vote for this settlement will breed racism. Let's call it politically blessed resource apartheid. Our governor and attorney general have to deliver the goods to the people that put up the money to put them in office. During phase two, the economy also stops growing. As the fish are depleted, tourism drops and jobs become scarce. Phase three is when the fish are gone. Now we are in the phase of big budget deficits. Not only do we have the deficits, we have a big social problem. No jobs. We netted away our local wealth and trucked it out of town. Here in Minnesota, the Arrowhead is in phase one. The Leech Lake area's agreement is in phase two. No economic growth, declining land values. Red Lake is in phase three, almost total collapse. In 1980, sports fishing tourism in Lake of the Woods County was only $18 million. The lake had been over-harvested by gill netting. Resorts were up for sale and going broke. Last year, tourism was $42 million in Lake of the Woods County. The fish are back. The economy is back. Rolling over 7 times, we are talking about $290 million worth of economic activity. Hundreds of new jobs in the Baudette area. Baudette now has 3 hardware stores, which also means people are fixing up their properties. 70 miles south on Red Lake, the fish are gone. The jobs are gone, the economy is gone. The fish are also gone in Washington State. The fish are gone in Oregon. The fish are gone in northern Michigan. The fish are gone on Rainy Lake, Mille Lake. A few days ago in the Minneapolis Tribune, there was an article about an Indian band in Oregon that painted the true plight of the Native American. The article really painted the picture of how sick our political system is in dealing with and abusing these people. They do not have jobs. The fish were gone. The article said the fish were gone. Phase 3, no fish, no jobs. Phase 3 is also budget deficit time until the fish come back. Then they are quickly netted and the process starts all over. 70 miles south of Baudette sits the town of Waskish on the shores of Red Lake. As you drive into the town, you will see a restaurant and a very small business community. As you approach the lake, you will start to see the old cabins emptying and rotting away. Empty and rotting away. No economic activity on a lake that is probably a better walleye lake than Lake of the Woods. But the gill nets have killed the economic vitality. Last year, Red Lake collapsed again, and we heard that only a couple 100,000 pounds of walleyes were netted. At $5 a pound to the Indians, that would mean $1 million worth of sales, which rolling through the community 7 times would mean $7 million worth of economic activity. Whoopee! $7 million worth of economic activity from one of the premier walleye lakes in the world. 70 miles further north, where we stopped the netting in Lake of the Woods County, we have $290 million from sports fishing tourism and the jobs this much money could produce. That means $250 to $280 million of economic activity just went poof in Red Lake County and disappeared into the thin air because of the deadly gill net. Last night on television, Channel 5's Jason Davis traveled to the Leech Lake area to do a show on how well the agreement is working. He talked to the Indians only. They said it was working great. Well, we're here to tell you that it's not working great for the vast majority of the citizens who live up there. When cabin rates per week go from the 4th highest in the state 20 years ago down to 16th now, that shows a big economic decline and poor management of our fisheries resources. An angler will spend up to $40 for a pound of fillets. Rolling over 7 times in the local economy, that adds up to $280 worth of economic activity that benefits everyone in the local community. Now a handful of people go out and gill net the same fish. The netter probably gets a couple bucks a pound, and then the fish truck on out of town to a licensed fish broker or gets sold out of the trunk of a car. Either way, we are talking over $200 of economic activity and jobs going poof and disappearing into thin air for every pound of gill-netted fillets. Mr. Chairman and members of this committee, you have a big decision to make next week. The Mille Lacs Treaty has worked just fine for over 150 years. If you vote for this politically, secretly negotiated settlement, you will be voting to segregate our country and destroy the economic health and job growth in our state. We would like to state that the Hunting and Angling Club is supporting the efforts of some private landowners to intervene in this court case. If their efforts are denied by the 8th Circuit Court of Appeals, they are going to appeal to the Supreme Court of the United States of America. Last week you heard my good friend Bill Ursa sit in this chair and say that the plaintiff says this agreement is right, the defendant says this agreement is right, and the court clerk says this agreement is right. Mr. Chairman, in closing, we would like to say that we are in receipt of a letter from our Attorney General's office to legal counsel for the private landowners admitting that the state may not necessarily be able to protect the private landowners' interests in this litigation. Mr. Chairman, members of the committee, we don't think that's right. Thank you very much.
That was Formerly with the Minnesota DNR, I served in various capacities with the agency, including senior fisheries biologist when I resigned in 1981. I'm here today to represent the Save Lake Mille Lacs Association, which is an organization which consists of about 100 sportsmen and landowner groups which are opposed to this agreement. And what I'm going to talk about here today reflects a mixture of biological, social, and even a few legal concerns. And I'd also going to try to clear up a few misconceptions about things like gill netting. I'm a long-time opponent of game fish netting in public waters, and I was deeply involved in the Lake of the Woods netting controversy back in the early 80s, which involved non-Indian netters, by the way. So I'm against gill nets, period, I guess is the point. In fact, that was about 10 years ago today when we were fighting against the gill nets in Lake of the Woods. In my travels as an outdoor writer, I've had the chance to fish extensively throughout North America. I've seen what's happened on a lot of waters. I've seen what happens when waters that have been heavily netted have been free to the nets. And there's a lot of examples of that. I can name Lake Erie, the western basin of Lake Erie, Saginaw Bay on Lake Huron, the Bay of Quinte on Lake Ontario, Bay de Noc on Lake Michigan, and right here in Minnesota, our own Lake of the Woods. And the story is pretty much the same, wherever this has happened. The walleye population has literally exploded. And the size of the walleyes, what few walleyes were left were small, and they got big. And along with that change in the fish population, when a corresponding change in usage of those waters by sport fishermen and major benefits to the economy of those regions. And if you all have this paper that I passed out, I think I'd like to have you look very closely at a chart, table 1 on the back of this paper. I think it tells a very interesting story. What I've done here is I've taken some Minnesota DNR Creel census statistics for 3 lakes: Lake of the Woods, Leech, and Mille Lacs. And the reason I chose these 3 lakes is very simple. Number 1, they were the same 3 lakes that I used back in '83, because in '83, when I was doing the same comparison, I was using Lake of the Woods as the sick lake, because it was sick. The walleyes were averaging 0.99 pounds. It was over harvested by gill nets. Now I'm using Lake of the Woods as the prime example of a good lake, because it's switched around when the gill nets have been taken out. Now, I'd like to have you study these statistics here a little bit. They're very simple. What I've done here, on Lake of the Woods, of course, as I said, this is a lake where the nets were taken out. Started going out in about '84, and I think basically about '85 most of the nets were out. On Leech Lake, the nets went in about 1974 when this agreement was made with the Leech Lake band, and I've heard a lot of talk about how well this agreement has worked. And I'd like to have you refer to this chart here to see that maybe it hasn't worked quite as well as everyone seems to think. I'd also ask you to look at the numbers of fishermen. You see, back in 1981, there was 108,000 trips on Lake of the Woods. That's when the lake was being netted. Fishermen don't like to fish where there's gill nets. They go somewhere else to fish. Nets started coming out in '84. You see the numbers starting to come up. By 1987, 227,000 trips, 110% increase. Now the tourism implications of that are pretty obvious. What happened on Leech? 1966. That's going back a long ways. 217,000 trips. 18 years later, now normally you would have expected the fishing pressure to double or triple. What happened? Dropped 16%, because the nets went in 1974. Now it's come back up again. It's over 300,000 pounds in 1991. What I would point out to you that that's only a 41% increase in 15 years. That's not much of an increase. So things haven't really been so great on Lake of the Woods, or on Leech Lake, I should say. Now let's take a look at Mille Lacs. Got a tremendous management program on Mille Lacs, thanks to the DNR and the special regulations that the DNR has put in place there. And we've got a catch and release program that came into being here in about 86, around in that area. We were down, we were at 1.74 pounds in 62. It started to drop. 144, got down to 114 in 83. After the catch and release and the special regs went in, bounced up to 155. 1992 was 159. Pretty good. Now let's look at what happened with the fishing pressure. 129,000 trips in 62, 246 in 77, 245 in 83, 344 in 87. Last year we had the record 495,000 trips. That's a 282% increase in fishing pressure over that, well, I guess it would be a 30-year period. Fishermen do like to fish where there's no gill nets.
Mr. Chairman, my name is Steve Fraley. I'm here today. I'm an attorney in Minneapolis. I represent 6 individuals who own land in the ceded area under the 1837 treaty. First of all, the landowners were denied intervention, which means they are not full participants in the lawsuit. The counties were parties to this lawsuit at one time. The band subsequently appealed that ruling by the magistrate, and the district court judge found that the counties were indeed not properly interveners. Both the counties and my group of 6 landowners appealed the ruling to the East Circuit Court of Appeals. Oral argument was heard on December 18th, 1992. The 8th Circuit has not yet issued a ruling on the counties or the landowners' motions to intervene. The group of landowners, if denied intervention by the 8th Circuit Court of Appeals, is committed to filing for writ to the United States Supreme Court.
Mr. Chairman, I really object to all those lobbyists, high-paid lobbyists sitting behind here, summoning the members back, and they're cutting their deals behind us.
The United States Justice Department for 8 years and served the United States at that point. In 1850, when the President of the United States revoked their hunting and fishing rights, that basically meant there was a government action that at least purported to take their rights away, and that was enough to create a cause of action that they could have gone in to raise with the Indian Claims Commission.
Would you be willing to take this case for the state and have your fees contingent on winning?
Yes.
And Mr. Chairman, would you be willing to bind your firm in the next day or so to that?
If my firm would go along with it, I would.
Strong.
Mr. Chairman, maybe what I could do with 1855, it's, you know, I've tried to lay it out fairly clearly in my memo, but I think there's one particular fact that I want to bring to your attention because I was really struck by it. To me, it's sort of the analogous, analogous to a smoking gun from a litigator's standpoint. Because I did read the transcript of the negotiation between the Chippewas, the Mille Lacs band of the Chippewas, and the United States government in connection with the 1889 Nelson Act. And I found this quote that's on page 24, which I thought really went to the heart of the matter. There was a question from one of the Chippewas. This is after the 1855 reservation had been created. Then it was ceded away in 1864, but apparently not very effectively. So the United States government passes another law in 1889 and says, all right, all the reservations are going to be ceded to the United States, assuming there's an agreement by 2/3 of the bands. And then everybody either moves to White Earth or moves to Red Lake or stays where they are, not in a reservation, but in individual allotments. And so there's this negotiation with the Mille Lacs band, and one of the Chippewas asked this question. Another thing about the wild animals. If an Indian wishes to go outside of the reservation to hunt deer, will he be allowed to do so during hunting season? In regard to hunting deer, that is a matter for the legislature of the state to determine. You can hunt deer in any event. wherever you find them during the season set apart for hunting, and wherever the white man may hunt, your young men will have the same right to do so. If you commit any depredation upon any man's property, you will be punished for it. Now that language, first of all, I think is right down the middle of the plate here in terms of whether the Indians had any understanding whatsoever that they were going to be somehow outside of state regulation. The answer was no. They were specifically told that they were going to be subject to the laws of the state legislature. That's the state of Minnesota.
This is going to be one of the most difficult issues of the entire legislative session. Walleyes somehow just get to the hearts of people.
Well, first let me say that, you know, everybody's would like to settle this, but we do not want to be a part of a secretly negotiated agreement. The participants were the governor's office, attorney general's office, the band, the DNR. None of the property owners, none of the businesses, none of the citizens or the resort owners were ever involved in this process. The DNR is first let me say, the DNR is one of the best in this country. It's better than Wisconsin, by the way, also. And they have a very fine line that they walk. But then they've done an excellent job of talking to the public about prospective changes in laws and limits and all kinds of things. In this case, they did not. Nobody was approached. We tried to find out, and we found out that this was being secretly negotiated without any input from the citizens, from any other interested parties. This was done very, very secretly.
Bud Grant, do you agree with the following? That the white man came and took land away from the native people, the American Indian, placed most of them on reservations, signed treaties with them, however, and gave them certain rights over the land where they were placed. Do you agree with that?
I agree that there were many treaties all across this country that were negotiated.
Why should not those treaties be as honored today as they were when first established?
I think they should. And if we go to court and those are upheld, then we will be the first ones to say they have every one of those rights that's in those treaties, as long as it's upheld by the courts. But this has been sitting there for over 150 years. Now it's been brought to the fore. If they have those rights, by all means, let them have the rights that they claim they have, and if a court of law proves that, then we buy that.
I don't mind saying there's something fishy going on here. I've been looking for my rod and reel, but it seems to be gone, dear. And now you're trying to tell me I don't know where I put it away. Well, it sounds a little fishy, and that's all I'm gonna say. Oh, there's the little matter of the dog and the boat key. Now how the dog could have buried both sets is still a bit beyond me.